Shweta, what do you?
Namaste and greetings. I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, Prabhav Evam Niti Anusandhan Sansthan, Nai Delhi, extend my warmest welcome to you all to IMPRI Web Policy Talk. We are gathered today for a panel discussion on transforming climate litigation, the role of MK Ranjitsinh versus Union of India in shaping India's climate policy. This discussion is organized by the IMPRI Center for Environment, Climate Change and Sustainable Development as part of Web Policy Talk series. I welcome all of you to this enlightening deliberation and thank you for tuning into this discussion. Now let me introduce the esteemed gathering. Our chair for the session is Mr. Ashish Kothari. He's the founder and member of Indian Environmental Group, Kalpavriksh, and a senior visiting fellow at IMPRI. We welcome you, sir. The distinguished panelists for the session are Ms. Shibani Ghosh, Advocate on Record, Supreme Court of India, and a visiting fellow Sustainable Futures Collaborative, Ms. Bhargavi S. Rao, who is an independent researcher and educator and an environment activist based in Bangalore, and she's also a visiting senior fellow at IMPRI. We have Advocate Lara Jasani, who is an independent law practice professional based in Mumbai and a human rights activist and member of People's Union for Civil Liberties. And Ms. Tulika Gupta, research analyst and coordinator at the Council on Energy, Environment and Water, New Delhi. Welcome to all. We look forward to learning from our esteemed gathering. Now, without any further ado, let us start the program. It is my honor and privilege to invite Mr. Ashish Kothari ji to start the program with the chair's opening remarks. Over to you, sir.
Thank you, Shweta. Thank you, Arjun, Vaishali, and everybody else at IMPRI for this opportunity to discuss what certainly is a very interesting judgment with a lot of implications for the future of India in terms of climate and development and rights and so on. So I am by no means an expert either in law or in climate. I'm going to keep my opening remarks rather short because we have four people who are experienced and experts in their own fields, who will be giving us deep insights into this judgment. Just a few remarks, opening remarks from my side before turning it over to the four of them. So when I first read this, I think the morning after this judgment was delivered, because some of the headlines were climate as a fundamental right, and I was saying, oh wow, this sounds very exciting. And of course, there is a lot of interesting potential in this, which will come out in the deliberations with regard to the observation in the judgment that Article 9, the article on right to life, etc., should be extended to the right not to be adversely impacted by climate change. The language is interesting, and I'm sure our panelists will have something to say about that language also. But then when one read a little bit further into the judgment, both the potential and the possible, let's say, flaws or weaknesses or issues and problems with the judgment kind of appeared. And I have three or four comments on that. One is that it seemed as if in trying to balance the needs of the highly endangered species of bird, Great Indian Bustard in Western India and Rajasthan, and the need for us to deal with climate crises, the Supreme Court was making apparently a very balanced taking a balanced view of things and making a very balanced judgment. But if you dig deeper, this seems to be rather simplistic. Firstly, because the court's views on what is energy transition to deal with the climate crisis seems to be rather, if I was to be a bit harsh, rather superficial, where it simply says that we should not be extending coal, which I think is good, of course, but that we therefore need to get as fast as possible into solar and wind. And if that were the case, then certain habitats of the Great Indian Bustard may actually need to be taken over, but we will make sure that the core habitats are protected. Now, and then, of course, it also states the Government of India's goals with regard to climate change, such as net zero by 2070, 500 gigawatts of non-fossil fuel energy or electricity, 50% of our electricity generation by renewable energy by 2030, etc. And if those goals were to be met, then we certainly need to significantly expand solar, wind, and other renewable, so-called renewable energies. Now, the problems, of course, with this is number one, that the government of India, when it talks about non-fossil fuel energy, rather cleverly worded, it includes also nuclear and large hydro, both of which have significant adverse impacts, human rights impacts, but also ecological impacts. And large hydro is by no means climate friendly, as there is increasing scientific evidence to suggest that, apart from all the displacement of communities and the drowning of ecosystems and so on. Nuclear, of course, has its own other problems, apart from the fuel issue, the issue of it necessarily being extremely authoritarian, secrecy driven, etc. The other problem, I think, with this is that even if one takes solar and wind as the two biggest so-called renewable energy sources, the most attention that the government seems to be giving, and private corporations, of course, are giving, is to mega projects. And I'm sure our panelists are going to have things to say about that. Bhargavi, for instance, her group has been researching this for some time. We know that because of that, very large amounts of land are being taken over. These are lands of farmers, pastoral communities, and wildlife. Right now, for instance, we are in fact gearing up for a major challenge to proposed mega solar project in Ladakh, which will take 20,000 acres of land in Changthang, the most fragile, ecologically fragile area of that region. And there are similar already set up or being proposed across the country. Wind, large wind has also been a huge problem in many parts of the country. So this attention to mega projects is another big question mark. We also know that regardless of whatever environmental impacts these projects have, in its own wisdom, the government of India has excluded them from the need for environmental impact, clearance, which means that there is no real, genuine environmental impact assessment done. And I'm actually, I don't know whether I should be surprised or not, but it is not a good sign that the government, that the Supreme Court has also not sought an environmental impact assessment in the solar and wind projects that it has said must be taken up post haste. And finally, two, three other points. Somewhere in the judgment, the Supreme Court also makes this rather interesting thing that renewable energy would be more accessible to the poor. And I'm not quite sure of the logic there. And again, maybe the panelists can comment on it, because if these are centralized, very large scale mega projects, they still need very large scale transmission. And in terms of accessibility to the poor, they probably have the same issues with regard to whether it's coal or nuclear or any other such thing. So why renewable energy should necessarily be more accessible to the poor is not something that's elaborated in the judgment, but they say that. And finally, of course, we know that though it's nice that the court has said that we should not be expanding coal, we know that the government of India is expanding coal. And this relates to a very, very large blind spot in our energy transition, which is that there is no questioning of demand. How much demand is justified? What about all the luxury demand that people like us, the rich, keep making? And also no focus on redistribution, where those of us who are overusing energy and those of the poor who don't have enough energy, there's no talk about how do we actually redistribute, which would then reduce the need for extra power stations or power generation. So these are all fundamental questions to the energy transition, and unfortunately the court's judgment does not go into it, and it therefore gives kind of a blank check to significant expansion of solar and wind and other so-called renewables and non-fossil fuel without asking these sorts of questions. And I also wonder that when it talks about not the adverse impacts of climate change being a violation of a fundamental right to life, and that's actually good, why it does not in the same thing say that, okay, displacement from mega solar is also a violation of a fundamental right, or other such things that this kind of energy transition is entailing. So I think these are some sort of crucial questions. Many of us could also then ask this thing, why has the court not gone into asking the government to look for fundamental alternatives, which includes things like, say, decentralized renewable energy, questioning energy or restraining energy demand, especially by the rich, looking at efficiency in various things, looking at things like the construction sector, the transportation sector, and the enormous wastage of energy, and also looking at the fact that energy is not just electricity, but also many, many other forms, and what does one do about that. Those are the sorts of alternatives that perhaps it could have asked to search for in order to really be able to balance wildlife conservation with the need to deal with the climate crisis. I have a few observations also about its selective use of international agreements, but maybe I'll come back to that later. I've already said enough. Okay, so with those opening remarks, I'm going to turn to a very exciting panel. For no other reason than simplicity, I'm going to go according to alphabet, the first language. And all four panelists are requested to make their opening remarks with like top headlines. If you had 3 minutes or 4 minutes to explain to somebody what you thought was the exciting potential of or problem with this judgment, then what would be that top headline? So let's start with Bhargavi.
Thank you, Ashish, and thank you, IMPRI, for this wonderful opportunity. I think the judgment is like a warrant for the extension of the Great Indian Bustard. This, as you have already said, is going to open up RE projects across the Indian subcontinent on a steroid mode. As it is, we have encountered many challenges when it comes to local communities who have lost access to their land and livelihood. And it is putting them in a place where they will be unable to get back into a proper form, because the way land is being taken, I will speak a little later, is truly pushing them into intergenerational poverty. And just the transmission line from point A to point B, which is a habitat of this very important bird, was not going to resolve the climate crisis across the country. Because in the context of other energies, hydro, thermal, and various other things, it cannot happen at the place where it is used. Whereas solar and wind, to a large extent, can be generated at a place where it is needed. So transmission lines themselves are a huge problem when it comes to solar and wind. And this particular judgment definitely has also missed the opportunity of an ecocentric approach in the country, given that we had already had a few cases where the orders, particularly the Jallikattu case, or even the Ganga Yamuna case of Uttarakhand High Court, had set some trend to move towards an ecocentric approach. I was really looking forward to this particular judgment, and I was truly disappointed that it did not take that path. Thank you. I will stop here for now. Come back later. Thank you.
Thanks, Bhargavi. A perfect example of what headline opening statement could be. Thanks, but we will come back to you on some of these issues so you can actually go deeper into them. Lara? You're on mute, I think.
Thank you, Ashish. No, I tend to agree with Bhargavi in that. I think while the judgment recognizes the fundamental right to be free from adverse impacts of climate change, I think it just stops at that. And the entire approach that the judgment has taken, even by the manner in which it has dealt with the case that it had at hand of the GIB, has been to agree to relax restrictions which were put in place for environment protection in the name of renewable energy or just transition. So this is a very dangerous approach, and this approach being used in the future is going to have a potential to pit sustainable energy or renewable energy against environmental protection. And these are one of the main fears that we have as environmental advocates and environmentalists. So this was obviously not a very disappointing judgment. It's not what we expected from the court when we heard that a judgment had come on the recognition of protection from climate impact as a fundamental right. And of course, we will be using, this judgment in court in order to enforce this right. But the fear that's come in is, what will the manner of enforcement be? Because if we see in all of these big public infrastructure projects, the government has taken a stand that these public infrastructure projects will lead to better connectivity, will lead to a lesser use of fossil fuels, will lead to lesser congestion, or will reduce carbon emissions. These have been some of the justifications that they have given in the project feasibility reports that are produced in court. And they have pushed projects, saying that there's a larger public purpose that it serves, and it also takes them towards renewable energy goals, or at least towards, reducing carbon emissions. But at the same time, we see the impact of these big infrastructure projects, not only in terms of displacement, but huge amounts of environmental habitats that are lost. Even in this case, the court did not deal with the very important fact of, why is GIB becoming critically endangered? Why is it becoming extinct? It is because of the loss of the habitat. And what have you done by way of this judgment to preserve the habitat? Again, comes into question. So this is a very dangerous approach that the court has taken, and we'll have to be very wary.
Thank you, Lara. Thanks a lot. We will come back also, especially I think on the GIB, I probably want a little bit more from you and Bhargavi. Sorry for those who are listening in, sometimes we use acronyms. So the GIB is the Great Indian Bustard, one of the most endangered species in the world. Okay, so let's go to Tulika. Sorry, Shibani. Sorry. I'm losing out on my alphabet. So. Shibani,
Thank you so much. Yeah, so I mean, in terms of choosing 2 or 3 points which I want to highlight from the judgment, and perhaps we could come back to this during the discussion as well. I think the first one would be the treatment of adaptation and resilience as an important part of climate change and climate change regulation going forward. If we look at renewable energy and the way that renewable energy comes into this judgment, it's very much a mitigation tool. About, we reduce our reliance on coal and all that. So it's about mitigation. The court at many places talks about adaptation. There are places where it says we need to make our vulnerable communities be in a position that they're able to adapt, we have to make them resilient. So in terms of using the right words, it's there. But then one wonders, where did the court go with it? Because if you're talking about Article 14, which was really the one, thing that stood out, that you're not only talking about Article 21, which is always there in, shouldn't say always, but Indian environmental jurisprudence often relies on the right to life under Article 21. And we have a very rich jurisprudence based on that. But Article 14 is fairly novel in that aspect. Now, Article 14 in climate change is perhaps its relevance is mostly in adaptation and resilience. It doesn't make much sense in mitigation. It is that people are differently affected, are likely to be differently affected by climate change. People are differently placed, gender issues, people who are forest communities, people living in Nicobar. So all of those things, the judgment kind of gets there, but then stops short. And therefore, given that we live in a country like India, which internationally, incidentally, has always said that, we will not take on mitigation commitments. We are going to press for adaptation, resilience. They've talked about loss and damage. Then for the court to come out, fully in support, it's just a balance, clear lack of balance, which is unfortunate. And I feel it's a huge missed opportunity for the court to kind of push for adaptation, resilience action. And an example, and therefore, when you don't prioritize habitat conservation, and we talk about GIB, we talk about the lesser Florican, but the truth is that if we had protected that massive spread of habitat, it would have meant a lot more than just those 2 birds. I mean, it would have been ecology. I mean, so many other species that are relevant. So there's one issue of adaptation and resilience, which I think was a massive aspect that the court could have pushed for, and it didn't. And it would have been very much in line with CBDRRC and India's international position. The second issue is, if the court has recognized this climate right, what kind of guidance does the court give for future climate litigation? It's true that climate litigation is on the rise, very much at the nascent stage. rights language is something that Indian climate litigation hasn't yet engaged with much, astonishingly enough. So this court can certainly, and this judgment, I'm sure as litigators, all of us are going to cite this particular judgment, try and make a good case. I'm not, despite all of our reservations, we'll cite it. But the truth is, what kind of guidance does it give? When there is a balancing exercise, the court doesn't really give us tools to decide which way to go. And I'll just leave with one example. Now, if there is a right against adverse impacts of climate change, if there is a question challenging a thermal power plant project proponent could well make a claim that the power I produce helps in cooling, which makes communities more comfortable in a heating environment. So this right that perhaps could go both ways then. And it's dangerous. I mean, I know Lara talked about, and Bhargavi did too, that how this is going to be a massive push for RE and almost without reason. But and even as a litigation strategy, what kind of claims can be sought? What can be, it's absurd if you're talking about a climate right that a thermal power plant can now use. And as a lawyer, I can make that argument. I think it's a fairly strong argument that I'm going to be making people more comfortable in a warming climate. So that's the second point. And just the last point, and something that Ashish mentioned, I think this issue of not touching on demand, considering demand regulation, I think that again is unfortunate. Because this whole thing that we need to produce more without considering why do we need to produce more or supply more is something that cannot be left unpacked in the way that the court left it. I'll leave it at that.
Thank you, Shibani. You'll definitely come back to some of these issues and go deeper. So, Tulika?
Hi, and I wanted to thank you for inviting.
Did we just lose Tulika, or is it only me who I can't hear?
Yes.
Her video is stuck.
Can you hear me?
Yeah,
Yes.
now, yes.
So first, I would like to highlight three aspects of the judgment. First, I don't believe that the court has articulated a right against the adverse impacts of climate change. And while I would, of course, defer to the experts such as Shibani and Lara, I still would argue that the court has not articulated a right, because if you apply the inversion test, which was applied by the court in the state of Gujarat versus utility users in 2018, you'll see that, the inversion test essentially says that if you can separate the discussion, the obiter of the judgment, the discussion portions, from the ultimate decision, and the outcome would remain the same, then the discussion is not legally binding. Another time that the court has tried to separate ratio and obiter is in the case of Dalbir Singh. So in my opinion, in this particular case, the entire discussion on the right against the adverse impacts of climate change is part of the discussion portion of the judgment. And even I was unsure about this. So when I tried to clarify this, using the record of proceedings, where the court explicitly has issued an order saying that the operative portions of the judgment are only following para 63. So, and those portions don't talk at all about the right against the adverse impacts of climate change. Now, while as someone who has built a career or is trying to build a career in clean energy and climate, I would like for there to be a right against the adverse impacts of climate change. I believe that if tomorrow I were to approach the court and try to enforce that right, this argument of a ratio versus obiter is the first thing that I would have to address. So that's why I believe that the question of whether or not there has been a right, there has been an explicit articulation of a right, is to my mind questionable. The second thing I'd like to highlight is that even if there is a right, the court has not, even if there is a right, this whole idea of a dynamic interplay between protecting a critically endangered species and addressing climate change, conservation versus sustainable development. The way that the court has articulated it, like Shibani said, it leaves very limited clarity on what that remedy would be. So if tomorrow, say, the residents of, the residents of the Great Nicobar Island were to claim that developmental projects in that region were, would adversely impact their right against the adverse impacts of climate change, then it would be difficult to say how how that right would be enforced. So ultimately, I believe that the only way for us to get clarity on any of these, on whether or not there is a right and what the scope of that right would be, and what India's position on the right against the adverse impacts of climate change should be, needs to be articulated by the legislature. I think in some of your articles you have discussed, I mean, Shibani, I think, and Lara have all discussed the other countries that have actually put in legislation regarding climate change. So, for instance, the UK is focused on a more emissions reduction perspective, whereas other countries have a different perspective. It's sort of the emissions versus the conservation and environmental protection perspectives. I think that decision has to be taken by the legislature. And if we let the court sort of pull us in different directions, we are not holding our legislators accountable and asking them to really articulate what India stands for in this regard. So that's thank you.
Thanks a lot. Thanks, Tulika. I think, and I'm glad you mentioned Nicobar, because as we all know right now, the government of India is pushing through a rather I mean, it's such a crazily stupid project that it's almost laughable if it weren't for the fact that it's extremely tragic. 130 square kilometers of pristine evergreen rainforest, habitat of two threatened Adivasi or scheduled tribe populations, and much more. And it's interesting actually that the judgment specifically mentions Nicobari tribes. And I think some of us are trying to see how we can maybe even use that in our arguments against the proposed project in the Nicobar. So, okay, so I think we've got some really fantastic points already coming in from all four of you. Let's go a bit deeper into some of them. And then, of course, you'll all have time. If I miss out on some of the important points in my questions, then please just jump in later on. So firstly, let's take a very quick look at the Great Indian Bustard itself. It's not necessarily a climate issue. It is also a climate issue, of course. But I think Bhargavi and Lara both said that this does not really help to balance, or let's say, to actually protect the GIB, the Great Indian Bustard. So maybe if you can just quickly elaborate on that, Bhargavi and Lara, on why you think that actually the Great Indian Bustard may not be protected by this judgment. And then we'll come back to the climate and energy issues.
Yeah, thanks, Ashish. So I would like to take all of you and the audience to a case that Environment Support Group had filed and fought at the National Green Tribunal at the Southern Bench. This case was about the diversion of 10,000 plus acres of grasslands in central Karnataka to create the Science City. And the Science City involved a variety of projects, which include the building of DRDO drone testing center, BARC's uranium enrichment center, a chunk of land for ISRO, another chunk of land for Indian Institute of Science, which at that point they said they wanted to build a synchrotron, but later turned it into a talent development center, and another big chunk of land distributed to various bodies to create housing and townships and all that. And among that was 1,000 acres to a private entity called Sagittor Ventures to set up a solar park. So at that time, in this particular petition, we had brought in enough material to the court to show that solar parks are not devoid of ecological and environmental impacts. We had researched through the existing scientific literature at that time. We had also brought in a lot of affidavits from leading scientists of the country who were researching on open natural ecosystems. One of them who I can think of is Abhi from ITRI, Abhibanak Tamim from ITRI, then I think it was also Dr. Ullas Karant, Dr. Choksi, then I think also Dr. Sharat Chandra Lele. All of them had given enough evidence and affidavits and enough stuff to show that grasslands are very key. And this chunk of grasslands was home to the Great Indian Bustard, the black buck, and the lesser florican, all of which are in Schedule 1. And the case went on for about a year, and the court set up a committee, and the committee did.
Apologies, Bhargavi. For those who may not know, she's talking about Schedule 1 of the Wildlife Protection Act, where species are and their habitats are supposed to be strictly protected. Sorry, go ahead.
Yeah, thank you. So after about a year, and after the committee that was set up came to the grasslands, held consultations with the local people and gave appropriate recommendations to the court, and based on that the court gave the final order. And in the final order, while the court said that all these agencies can set up their shops only after an environmental clearance, none of them abided by the court order. They all did what they did because I think they felt that they're all above the law, because these are all the big institutions of the country, so they didn't care much about this order. The second thing, there are about 8 or 10 points. I will not go into each of them. The second thing that the court had said was that since this area is recognized as a habitat of the Great Indian Bustard, it has asked the government of Karnataka to come out with a state action plan at that point of time. This was exactly August 2014 when the judgment came. It's been 10 years now. The government of Karnataka did nothing about the action plan, state action plan for the Great Indian Bustard. And another point was it asked the Ministry of Environment and Forest and Climate Change to go and revisit the decision of having removed solar parks from the purview of environmental clearances, because this whole removal of solar parks was based on a simple office memorandum. But again, MOEF and CC did very little about it, and it has continued to hold the position that RE projects are benign, they don't cause any pollution, so they don't need an AC. As a result, what has happened is, the Science City came up. And what is very important is the central part of Karnataka is kind of contiguous with Maharashtra and parts of Andhra Pradesh, where this entire stretch, if you can even open your Google Maps and Google Earth and see, you will see that, Chelkere, Pavagada, this place called Rolapad, Paddu in Andhra, that was actually a sanctuary. All of them are kind of contiguous. They formed a beautiful open grassland natural ecosystem for the Great Indian Bustard and the black buck and all these species. But the Science City came, and soon after Pavagada took away another 13,000 acres for the solar park. And then came a whole lot of other mega infrastructure projects, completely destroying this habitat. And obviously, Karnataka at that point had some 10 numbers of the Great Indian Bustard near Siriguppa, a place north of the Chelkere grasslands that I'm talking about. And last week's newspaper reported that there are only 2 Great Indian Bustards left in Karnataka. 2 years back, newspaper reports said that Andhra Pradesh had lost all of its Great Indian Bustard. In this context, what is very appalling is the fact that such a case has already been fought in the country, and the court has already given a certain direction, and the concerned agencies have not done anything about it. And a case like this is completely forgotten at the Supreme Court level. And there is no coordination, there is no going back into your law books and things like that. And this was also a case that was systematically fought. If it had not been for my colleague Leo Saldana, who fought this tooth and nail at the NGT, bringing in all the scientific evidence in support of the Great Indian Bustard's habitat, and also in terms of the solar parks causing ecological damage. And also I should mention the efforts of the lawyer T. Mohan, who represented ESG. Leo fought as a party in person. Then we also had Clifton Rosario, who fought representing the local communities of the region. And all three of them did an amazing job. Unfortunately, again, our court procedures probably don't have the notes and the arguments all documented very well, that today you can pull out all of that and show it to the people of the country that these points had been argued. As somebody who has been through all the hearings for that 1.5 years, I think they were the finest arguments ever made in support of the habitats of these animals. Today it is Great Indian Bustard, but what happened in Assam with the Mikirbamuni Solar Park, it's elephant territory there. So this case will give leeway to panchayats to give no objection certificates, for water resource departments to give no objection certificates, for forest departments to give no objection certificates, for setting up of all kinds of renewable energy parks. So tomorrow we will also have waste to energy projects coming about anywhere and everywhere, and forest departments will be forced to give no NOCs, saying that, oh, Supreme Court has said this, so they have to give. So this is the fear I have, and thanks for your patience.
Thanks, Bhargavi. Actually, you already kind of answered a second question I had to you, which is a little bit of elaboration on the impacts of these mega so-called renewable energy projects, where you already given some. Maybe later on you can also add some more. But Lara, would you like to comment on this, on either of these, like impacts of mega projects of this kind, but also specifically the Great Indian Bustard?
No, I think Bhargavi has actually covered a lot about the GIB, and they were invested in the case. But one thing that I want to add is that the Supreme Court judgment proceeds on the basis that that we have a very strict policy in place in terms for environmental protection. And in fact, it lists down the laws that we have in place. It also talks about how several schemes have been brought about by the government, and in that it also includes the carbon credit program and several other schemes. And it also talks about it also proceeds on the basis that these laws are sufficient for the protection of the environment in a sense, and that is where I think the biggest fault lies. What Bhargavi also explained, that in spite of judgments being passed by the courts, there has been very poor implementation. Even when the law was in place, there has been very poor implementation. But one of the biggest problems has been that in the last decade, we have seen a complete dilution of the environmental policy. And as such, our environmental policy is not protecting the environment or the natural resource. There has been bypassing of public consultation process in granting of any of these clearances to projects. And here I'm talking about the thermal projects, I'm talking about mineral benefaction industry, we are talking about all of them. There have been huge exemptions that have been granted from going through the EIA process in its 4-stage process that has been provided under EIA notification. Also, we have seen that there has been a huge amount of dilution in the forest-related laws, and one of the biggest things that in the GIB case, now coming back to it, is one of the prayers that had been made in the original petition was for the protection of grasslands, which are the habitats of the GIB. And not looking into that, I think, was one of the which actually shows the bent of the Supreme Court. The grasslands, in fact, have been really under danger under the schemes that have been brought about by the government. And most of the grasslands are shown as wastelands. The entire green credit program was based on taking over of grasslands and using them for very faulty afforestation, or for earning green credits by companies when they actually divest or divert forests. So this is a really huge problem. The entire process of greenwashing that is already taking place through policy has been furthered by the Supreme Court. So that's where I feel that we don't see anyway the protection of GIB, but we are also not seeing any kind of environment protection happening through this judgment, especially. The only thing I think that the Supreme Court has done is to say that protection from climate change is a or impact of climate change. Protection from climate change is a fundamental right protected under Article 14 and Article 21. And apart from that, it is done exactly the opposite in terms of environment protection. So I think that's where that's the crux of the judgment. That's where I am very bothered with it. And yeah, I mean, we discuss it further now. Yeah.
Thanks, Lara. And I think I'm going to come back to you and some of the others on the whole issue of implementation and dilution. But before we do that, also given that Tulika is actually saying that it probably is not a new right because it's not in the operational parts of the judgment, it's in the discussion part. And I think a number of you, maybe all of you, have also said, at least in the articles that I read, that one thing that's absolutely essential after this is for there to be comprehensive legislation or a series of legislations and policy on climate. So let me go there, and then we can come back to the issue of implementation again after this. So I want to ask Tulika, I think in one of your articles you mentioned about this and said something about the laws in Chile and Uganda as possible examples of where not to go or where to go. So if you could maybe elaborate a bit on that. And Shibani, I think you mentioned Kenya as a possible example. So if you could just, both of you, elaborate on what you would mean, what is the potential for a comprehensive legislation or series of legislations emerging from this judgment, and what would that or what should that contain? So let's start with Tulika.
So in terms of what the kind of legislation, that umbrella legislation on the climate that should ideally, in my view, be put forth, is something that balances the need for clean energy with the need for environmental conservation. I think that addressing climate change needs clean energy. It's not like we can do it without clean energy. We can't do it with coal for sure. So there has to be some alternative source of energy. In the beginning, you had mentioned two questions. You said that why is it that the court believes that renewable energy would be more accessible to the poor? And why is the government focused on large-scale projects? I think I can answer that separately as to why that may be the case. But broadly, I think that the government needs to articulate how these rights would be balanced and create a clear implementation framework for environmental impact assessments. I don't believe that clean energy projects should be free of them. They should be there, but we are in the next 45 years in the journey to 2070 likely to face more such situations where clean energy projects will be conflated with environmental environmental protection, whether it's in terms of whether critical minerals should be harvested from the ocean, or whether in terms of more habitats being captured for solar power. I think that's something that really needs to be there. There also needs to be very clear enforcement of the goals that the government is stating, whether it comes to demand reduction, because the government has committed to 45% reduction in energy intensity under its nationally determined contributions, which was discussed in the judgment as well. But that needs to be supported with monitoring, reporting, and verification, because you can't say that you've completed a target without actually showing evidence for how that target has been achieved, which currently we're not able to see. We don't have data transparency, so that would be something that would really help. And it would really help to provide clarity on what the remedies are if these different rights against the adverse impacts of climate change, whether in terms of adaptation, mitigation, resilience, how those need to be enforced. Because I feel that in the long run, especially in the next 45 years, you cannot have a situation where for every conflict, you have people filing PILs and approaching the Supreme Court. I don't think that's a sustainable or realistic way to achieve any action. Because what tends to happen is that projects, one way or the other, get stalled, whether it's a conservation project, whether it's a conservation project that's fighting against the development of a clean energy project, or any other kind of project. I mean, the moment you go into litigation, the likelihood of either one being scuppered because of litigation is very high. So there needs to be clear processes in place.
Thank you, Tulika. Can you just very quickly in a minute or two talk about Chile and Uganda, because those were examples now. So what is in their laws which we can use or should not use climate laws?
You just discussed Chile and Uganda in the context that the right exists, where these countries have implemented legislation to address climate change, but not because from what I recall, the laws in those two countries don't apply to India. For instance, Chile is looking at a situation where they are going to become one of the leading producers of critical minerals, whether it's lithium or copper or anything else. So the kind of legislation that they have would prioritize their in their desire to become a net exporter of energy, whereas Uganda has a very different priority. So I don't think that those are necessarily examples that we should try and learn from.
Okay, thanks. Shibani?
Yeah, thank you. So yes, the reason why we have been talking about me along with other colleagues, Professor Navroz Dubash, Aditya Pillai, we've written about this as well. We've been talking about climate law for some time, and then the Ranjitsinh judgment kind of reinvigorated us to talk about it more, because if you're going to have three people sitting in the Supreme Court and trying to unpack these kind of very complicated issues of balancing, that's, as in fact Tulik also mentioned, that's not an advisable way to go forward. And in fact, if we look at the judgment, finally what does the court do? It rolls back the restriction of the earlier judgment and it sets up an expert committee. So if the court is all the time going to look out for experts in the domain, then perhaps it's not the court's job to do this. And we need a way to do this, and it cannot be an ad hoc process. It has to be something which has some democratic accountability. There has to be transparency reporting. So yes, climate law is something that we have been thinking about. Now, in terms of what a climate law for India could look like, we've given it a bit of thought. One thing is that we cannot go down the route that many developed countries have gone. For instance, the United Kingdom, where the focus is very much on emissions. The truth is India's carbon emissions are likely to grow. And we have requirements. So perhaps our law then has to look at slightly differently and tailor it to a developing country context, such as Kenya, South Africa, where we then focus on adaptation and resilience, because that is, while not at all, not looking at mitigation, that's not something that we are proposing, but we need to keep the focus on resilience, adaptation. We are also suggesting that a law of this nature, if it were to come about, cannot be something, certainly not at this stage, which is regulatory. It has to be something that's enabling, because given the nature of the climate problem, we at this stage at least have to facilitate coordination, knowledge sharing, knowledge building, kind of getting our communities together, learning from them. It cannot be top down, which is something that the South African law also isn't, because they have set up kind of institutional capacity starting from the lowest level of administration. So thinking of climate law in that terms, which is tailored to the Indian context. And in the Indian context, we have a few other kind of specific things. Firstly, our federalism. So we can't forget that we have a very strong federal structure in place. Issues such as public health, buildings, many of our sources of emissions is not something the center could ideally legislate on. And a lot of the institutional capacity is also at the state level. So to then assume that a central law can come in and resolve all the problems would also be perhaps ill-advised. And the second thing is we already have a lot of sectoral legislations. So let's not try and reinvent the wheel on everything. Perhaps things need to go in parallel, an umbrella legislation which is more about facilitating, knowledge sharing, building participatory processes, but also, I mean, looking at coal, looking at other sources, industries, which are all sources of emissions, kind of those sectoral laws also need to kind of come in at the center as well as at the state level as well. And as I said, that it has to be kind of tailored to the Indian context. And really the idea is, and I have to say this, I mean, many of us who work in this space probably have felt that these issues shouldn't go to court, whether it's the Supreme Court or any other judicial forum as well, that these are issues that have to be democratic, through a democratic process have to be resolved. We cannot have unelected members who admittedly don't have expertise in this area resolve this. And the way the courtroom is set up, it is it is set up for cherry picking. It is set up for people, an adversarial setup that one party will come and say this, the other party will come and say this, and the judges are forced to choose between those because no one came and told them about the fifth jurisdiction. So, it's, and Ashish, you mentioned this in the beginning about why they chose those jurisdictions. Come to think of it, the outcome of those three cases that the court refers to has no relevance. I mean, it's just randomly picked up three cases. It's welcome because it shows the openness of the court to engage with international or foreign jurisdictions. It's important in an evolving context. Climate is complex. It's not easy. But it does this, and then how did it move from there to how did it affect its final decision making is not clear. But I'll stop here for now.
Thanks, Shibani. Just on these international laws, but I don't know if we'll be able to come back to that point. What struck me was absolutely what you're saying. It's very cherry picking. So they've selected two or three or whatever of these global things and said India needs to follow those. But for instance, it ignores the Declaration on Human Rights, the Declaration on Indigenous Rights, the many parts of the Biodiversity Convention, which actually talk about much more balanced approaches, rights-based approaches. The Rights of Nature Declaration, of the UN, but also many other countries. So there's a whole bunch of things which it kind of either doesn't know about or chooses to ignore. And that makes it very problematic in many ways. But I mean, this is a point, maybe later on we can come back to it. I just wanted to mention that. I want to go back to, supposing we do get a comprehensive legislation or changes in existing legislations which are relevant to this. So we don't, obviously one law, like you said, cannot deal with all of this. But supposing we do get that, in a situation where we've seen that the commercial and profit-making and power-hungry dominant forces that we have in India and elsewhere in the world are very easily able to ignore laws. We see that all the time, right? So, example that Bhargavi gave, for instance, and many others that we know of, and of course, certain industrialists who are not to be named are given special preference. So, in that situation, obviously, it's not enough to have law. We need to go well beyond that. Maybe this is something that Lara, you can come back on, because I think you'd also express some skepticism also about law, if I'm not mistaken, in your initial thing. So maybe you can speak a little bit about this. So we do have plenty of laws. There could be more laws. Maybe there should be, or a comprehensive policy at least under which new laws are made or existing laws are modified. But then what happens with the implementation in a situation where the forces that be, the powers that be, are easily able to ignore, sidestep, and violate them without consequences?
So, there are two concerns, and there are two levels of concerns right now in the existing, policy framework that we are dealing with, especially in courts. One is, of course, that, the laws have been weakened. For the ease of doing business, there were, several amendments that were brought into the existing policies. And so what we're dealing with is what was irregular earlier has now become regular. What was, what required, going through an entire environment impact process now no longer requires going through an environment impact process, or where public consultation or Gram Sabha consents were needed in order to get even a stage 1 approval. Now you can go ahead, get a stage 1 approval, start preparatory work without any of these processes. So we're talking about a very severe dilution that has taken place of the law. And by that, we're talking about the CRZ notification. There is a coastal regulation notification, again, a very important climate law. So when we talk about, when we're talking about, we need a climate policy, the concern that I have is that, is this climate policy in the name of just transition or in the name of, sustainable development or going to renewable energy, going to be posed against the environment protection laws? Because many of these environment protection laws were also to serve as climate policies. So you have the coastal regulation zone notification, which is a climate policy, but it has been very severely diluted. You have the EIA notification of 2006, which has suffered more than 150 amendments. And it has been diluted, in spite of all the various, climate-related schemes and policies and international commitments of India, the domestic legislation has suffered. I mean, even under the Paris Agreement, we have agreed to, introduce the climate considerations in our domestic framework, and that has not happened. So all our existing laws have been diluted on the one hand, right? So when we talk about climate policy, we can't have a situation where, Tulika was saying that we are going to see a lot of, questions of environment protection versus, setting up of solar plant, habitat loss versus setting up of, renewable energy. But the question is, why should it be opposed to each other? That is that is the fundamental area in which, the concern lies. Where are the alternatives? Are they being looked at? Is the information that we are getting whole? Are feasibility studies that we are getting just using climate language, or are they actually looking into climate considerations? So at many levels, apart from the policy issues, we have all of these various considerations at the stage, before law comes into place, at the regulation stage itself, at the monitoring stage itself, at the compliance stage itself, at the implementation stage itself, where there is a lot of greenwashing that takes place. So it's not just about the policy, but it is about the manner in which the policy is also being implemented. That is a huge area of concern. So when we talk about climate policy, we will have to talk about the dilutions that have taken place. How do we get our laws back? That is one of the first things that we're looking at. The validity of an environmental clearance has been doubled under the existing laws. And this is in spite of the fact that we've had technological advancements. Even all these international covenants talk about these technological advancements that are supposed to be climate friendly, but we are still, construction time has reduced. So technically, the time to construct projects, the time to put the projects into motion has reduced, but we are seeing that the validity of environmental clearances have increased. This is only to ensure that the climate considerations are not looked at for an extended period of time. You don't have to go for fresh clearances. You don't have to go through the entire process again. So this is at a time when the climate is also rapidly changing. So these are really when we look at a climate policy, again, we'll have to look at that. The second part is implementation itself, the way in which the entire administrative machinery functions, whether it is the Ministry of Environment, Forest, or whether it is a pollution control board, whether it is the state authority, whether it is a district authority. What is the manner in which these bodies are functioning? We have seen very low rejections now. There was a time when there would, environmental clearances would not be granted, and that you had industries, complaining about how there are hurdles. That's how the single window clearance came in. But right now, we are not seeing any rejections taking place. All forest clearances were granted. The forest diversion is taking place rapidly, right? So the kind of language that is being used in these environment impact assessment reports, again, where there has been a lot of a lot of climate language that has creeped into many of these documents, and they become justification for allowing these projects. So it's a complete cover up, a complete sham process that takes place in the name of obtaining environmental clearances. So these are very critical questions that have come in. If you're looking at actually protecting the environment and looking at climate action, we will have to look at how the domestic framework is actually progressing. Another point that was made by Shibani was that we're not just talking about the central laws, right? We're also talking about how development control regulations in different cities are, framed. We're talking about how the development plans are coming into place. We're talking about how the coastal zone management plans are coming into place. How many areas are getting de-reserved from being a natural area? How many of areas are being de-reserved from being a no development zone? So we'll have to bring all of them into sync right now, because all these policies are disjoint. We are not seeing implementation happen at every level. And even when policies come in, they are mainly paper policies. Even this judgment coming in and deciding that, okay, we have a right, is going to be a paper policy unless it actually translates into laws at a local level, regulations at a local level, and a regulatory system that is functioning. So these are, some of, they're very, I'm not trying to paint a very, sorry picture, but the question is that all of this will need to be factored into, the climate policy drafting, in understanding how we can move ahead from this, how we can, bring back our rights, how we can, dismantle the structures that are in place right now. These are going to be very critical questions.
Thanks, Lara. I'm going to come back. I want a question on adaptation that we should address, and then I'm going to come back to the issue of what are the alternatives, which deals with some of the sorts of issues you're talking about, but also on the issue of federalism, because I think we need, obviously, and this is something I'm sure you'll all agree on, we need to go well beyond center and state and look at the empowerment of local communities, which is still very, very inadequate. But I'll come back to both of these things. Before that, Shibani and anybody else would like to, how do we deal with adaptation in a much more comprehensive way? What are the adaptation issues which emerge, obviously not just from this judgment, but everything that's happening in the climate crisis, and how can we deal with them? So,
sorry, Bhargavi, please go ahead. Yeah, she raised her hand, sir.
Yeah, sure, go ahead.
Yeah, so I think in the context of adaptation, again, it was the courts that, directed all the states to come out with their own state action plans to address climate change and get them approved by the Minister of Environment and Forest and Climate Change. All the plans were a very top-down approach involving a lot of technology and again involving a lot of industrial input. I cannot think of any one plan that came ground up. The most vulnerable in any city are the Paura Karmikas, the solid waste workers, the taxi drivers, the domestic helps, the sex workers, the LGBTQ community. These are sections of society who are largely ignored, and it is they who bear the brunt of climate change. First, they will not have proper housing, they will not have proper access to clean drinking water, they will not have access to healthy food, they are far away from healthcare, their children can't access a good education. So these are some of the very crucial factors when it comes to climate action plans. And cities are forgetting the fact that these people even exist. Most of the plans that are made are, like I said, top-down approach and largely based on technology. So that needs to change. And I think city after city has to go down to the ward level. Unfortunately, the 73rd, 74th Amendment has not been implemented, but that is where we need to go back. The drawing board has to start there. And if every ward can have a climate action plan based on the vulnerable communities who exist in that ward, where they live, whether they are living in low-lying areas, what kind of lakes exist in tanks or lakes exist in that area, what kind of encroachments have happened, speaking from Bangalore, because all our lakes have been frothing, fuming, or overflowing when it rains. So starting things from there is very important, and that needs to be built into the policy. Yeah, thank you.
Thanks, Bhargavi. And everybody, please feel free to jump in like Bhargavi did. So just, because I'm only pointing to some people, but of course others will have things to say. Shibani, go ahead.
So I had two examples in mind. One actually came from Ashish, what you said, and actually the discussion, grasslands. Now, actually, grasslands are supposed to be fantastic natural carbon sinks, right? So I think as that's a mitigation and adaptation point. I think this whole approach of devaluing habitat conservation, looking only at keystone species, which also we don't do very well. But I think that has to change. And I'm sounding like an optimist, which I'm not. But at some level, the adaptation has to start thinking about all of this, because it's so important given where our communities, particularly vulnerable communities, now are situated. Lara, at your point on the leniency in the laws and dilution of the laws is very well taken, particularly in the forest area. And I think that is something that we really need to push back on, because protecting our forests and our natural habitats, I think will really go a long way in making our communities, local communities, much put them on a stronger footing to face what is going to come for them. So perhaps that kind of backstopping the dilution of the law. I mean, forget about making them stronger, but at least not to ensure that they don't dilute. The second example that comes to mind is actually heat action plans. And there's a lot of work that has now started. My colleague Aditya has started doing some work, and across the country, we are seeing several heat action plans from cities as well as states. And it's crucial. I mean, just looking at so many cities now, reeling under the impact of heat, and many of these plants are at nascent stages, and therefore I think it's a great opportunity to people who are able to contribute to this process. And while I have also looked at regulatory institutions being critical of the way they function, and how poorly they have been staffed and all, but I also, when I speak to some of these people, for instance in the pollution control board, their response is, we don't have access to resources. People don't tell us what to do. Like, tell us what to do and we are willing to put our money. So sometimes they're in this position where they don't have solutions. There are these odd bureaucrats who are open to ideas, open to spend the money, put their neck on the line. And then perhaps many of us need to reach out to them and say, look, this has worked, likely to work. Let's do a pilot. Let's do something. So I feel like heat action plans is just another example, Ashish, to say where adaptation has to start kind of being weaved into our policy. Otherwise, and I take your point that we should not be urban focused. I mean, obviously, this is going to affect so many all parts of the country. But just as an example of where work, I think, is starting and can go a long way on adaptation.
Thanks, Shibani. I think taking off on that heat action plans thing, I was also looking at them a little bit, and I think one of the things that struck me, I mean, some seem to be good in terms of making the city administrations accountable to those who are most badly affected by heat or extreme heat. But one thing that struck me was that it didn't seem like any of them, or maybe, I mean, I didn't look at all of them, but none of the ones I did see seem to actually deal with the fundamental factors of vulnerability. The sorts of people that Bhargavi spoke about, street workers and so on and so forth, even say traffic police, and so the factors that make the fundamental structural factors that make them vulnerable, both in their working conditions and their living conditions, are something that would need a much kind of more fundamental reorientation of city planning, or who decides on city planning, and of course much greater participation of those people in decision making. So that's something that I found was lacking, and a lot of the effort was in terms of either charity that the governments will provide for those who are going to be badly affected, or technological solutions, all of which are important, but we obviously need to go deeper. And that brings me to this question. So a couple of more questions, and then we're going to also start addressing some of what there's been a few questions and points from the audience. So I think we're all kind of agreed that we do need more fundamental transformations if we want to really tackle the climate crisis from many points of view, including the most vulnerable and including wildlife, which is also very vulnerable. Then we need something more fundamental. And to me, it seemed like the sort of technocratic or technological direction that this judgment by the Supreme Court, and many judgments previous to that also giving, are kind of ignoring the non-technological, more social political alternatives. For instance, in the case of forests, much greater collective tenurial security and rights to communities, which the Forest Rights Act does kind of provide, but then most governments, across most of the country, it's not really been implemented because, well, for obvious reasons, certain departments lose their power. Or, for instance, land rights to small-scale women farmers who are doing the most incredible job producing food with no chemicals, with their own seeds, ecologically friendly, climate friendly, etc., without being called climate smart, which is a whole other ball game. Or urban wetlands, which I think Bhargavi you mentioned, or Shibani you mentioned. So the sorts of more, what should I say, those which require more socio-political, cultural transformations and economic transformations, which would be approaches also to deal with the climate crisis, seem to be missing. I mean, certainly in this judgment, but also missing from any of the climate action plans that, at least that I've seen. So any of you would like, and I think Bhargav, you mentioned the need for more ecocentric things, and I mentioned rights of nature, for instance. So any of you would like to jump in on that? What are the more fundamental alternatives that? Yeah.
Yeah,
Bhargavi
again,
is
so see, if we go back to NAPCC and its 8 missions, there's a National Solar Mission, then the Mission on Sustainable Habitat, the Water Mission, then the National Mission for Sustaining the Himalayan Ecosystem, then Strategic Knowledge for Climate Change, then there is a Green India Mission, and then this Mission for Sustainable Agriculture. All of the focus has been only on the solar mission. Very little attention to the rest of it. City after city is having a major water crisis. Habitat is a major challenge again, sustainable habitat, because we know the poor today are being evicted everywhere and anywhere in the name of beautification projects, and there is no plan B for them. When it comes to the strategic knowledge itself, do we even see our municipalities talking about climate change and how they want to address it, while city after city is also signing up for the Paris Climate Accord? Bangalore did in 2021, but they really don't know what they signed up for, because we don't see any ground level planning, for instance. Then in the name of Green India Mission, unfortunately, I was referring to the grasslands earlier in the talk. The same grasslands had 3,000 acres of land that was the grassland that was left, and the court very clearly said that those 3,000 acres have to be protected for posterity. But in the name of Green India Mission, that land was given to some religious institution to plant trees. Then in the name of sustainable agriculture, very recently the biofortified seeds have been released. I am fearing that if it is some kind of GM seeds that is getting a backdoor entry, I hope I'm wrong. So, why all the attention only for the solar mission among the 8 other missions was something I just wanted to talk about.
Thank you. Anybody else want to respond to this? Lara, go ahead.
Yeah. No, when we see the Mumbai Climate Action Plan, for instance, right? It talks about, it talks about the virtues of, public infrastructure. It talks about public transport. It talks about, several, adaptation measures as well. At the same time, it also factors in all the infrastructure development that is taking place in Bombay, which is multiple infrastructure projects, from freeways to coastal roads to, big flyovers and everything that are taking place simultaneously in Bombay, and and contributing to the cumulative load of the city. So we see a big dichotomy between what is happening and what is written in these climate action plans. So the whole question is that these climate action plans shouldn't just become another, a paper formality or a greenwashing measure. And that's one of the biggest fears I have. One is these climate action plans are not even enforceable. They're not legally enforceable. They're only providing a framework or a sort of a plan to the local authority as to how it should proceed in terms of the challenges of climate change. But at the same time, it promotes the same developmental model. And our challenge is to this developmental model. And I know I'm coming back to it again and again, but it's at the crux of the matter. Here, in all of these, these climate action plans are of no use unless there are restrictions in place, unless there is a moratorium on certain kinds of development, unless there is a moratorium on taking away, environmentally protected, ecologically protected habitats in the name of green energy or in the name of, any kind of land grab. Unless there is protection of rights of Adivasis. These climate action plans are of no use unless, in Bombay's context, it factors in the protection of the coastal areas and the rights of fisher folks. So there is a huge sort of a dichotomy between what is happening in terms of the regulations that are there actually for protection and these climate action plans and the kind of mechanisms they propose. Because most of these climate action plans are proposing to work within the developmental framework. We need different kind of climate action plan is basically what I also wanted to put. And even when we talk about, the kind of, we need a mindset shift, right? And that mindset shift, I think, is not coming through any of these policies. So we need more of, and this is why I feel it's very important for us to not just depend on policy. We need a climate consciousness and a climate movement. And that is something that we all also need to work for as advocates. We will not be able to rely on policy because I don't see the intent of the government in trying to bring in climate-friendly policy.
Thanks, Lara. Tulika, yes.
I think from what I've heard today and from what I've heard for many years while talking to different groups of people who work in the climate space in different contexts, whether it's in clean energy, whether it's in activism, I think what we need for a really robust climate legislation that addresses the concerns of different stakeholders is philosophical consensus. I think we come at this problem from multiple different perspectives. Some people come to it from a perspective of having fought for the enforcement of environmental protection laws for many decades, and having seen that that these laws are not being enforced and they're continuously being breached, and perhaps in some senses a newer generation who's trying to build a career in climate or trying to build this vision for what their lives will be like in 2070. I think somewhere there has to be some amount of there has to be a bridge between these two perspectives, and the reason for that, there are two reasons for that, right? So some of our environmental laws were passed in the 1970s, 1981, before climate change was even recognized as an existential threat the way that it is today. It was only in 1982 that the Stockholm Declaration was passed, right? And second, things like clean energy. So just as an example, if India is to meet all of its energy needs from solar energy using current technologies, which is our solar PV, etc., it will require 5% of our land mass. Now, if you're looking at using 5% of your land mass using current technologies to create this clean energy world, there will definitely be conflicts. So how do we approach that conflict? And that's something that a climate legislation for India needs to sort of address. And the only way for us to address multiple different types of concerns is to have this philosophical consensus, which lays out a vision for what different groups of stakeholders want for a more climate friendly future for India. And when it comes to environmental integration, whether in our cities, whether in terms of adaptation and resilience, whether in terms of the way that we design our heat action plans, or in terms of the way that we design our resilience plans, like what's happening right now is India is in this tricky position where we are trying to attract investment. So say investment for nature-based solutions. We're trying to attract investment for clean energy. We're trying to attract investment based on definitions that we don't really have control over, based on ideas that we don't really decide. Unless we lay out a vision for ourselves, we will be stuck trying to fit into someone else's definition of what constitutes, what is good for the climate. And the only way that I personally feel that we can get there is by pushing for philosophical consensus, by having more of these conversations and trying to find common ground, so that whether it's this government, any other government, there is a clear articulation of what a strong climate legislation could look like that addresses different aspects of the problem.
Thanks, Tulika. I think this is going to bring me to the last point or question that I want to raise here, and then turn it over also to the audience, which is that I think in everything that all of you are talking about, one thing that seems to be absolutely essential is what is the role of communities on the ground, those who feel the biggest impacts of the climate crisis, development projects, solar projects, whatever it is. It's people like you and me are not that badly affected as those who are, Adivasi communities, fisher communities, small scale farmers, pastoralists, and so on. And when we're talking about mindset shift away from, say, the current models of development, or maybe even the currently dominant models of conservation, I mean, we just heard last week the shocking news that the National Tiger Conservation Authority wants the displacement of, 40 lakh or something like people from within tiger reserves. I mean, we still have that colonial mindset of what conservation is. So if one is talking like that, then I think there are two very essential questions or issues to raise. One is that we have a model of development which is defined and dominated by capitalist and or state dominated institutions. And unless we are actually able to challenge that itself, I think it'll remain there. And, we say, India says in international circles that we need the right to development. And of course, nobody can disagree with that. But then if the right to development means expanding coal mining in Chhattisgarh, to the detriment of local Adivasis, or if it means, that's a form of internal colonialism, or if it means of self-reliant India, for instance, Atmanirbhar Bharat means expanding coal because India as a nation needs to become self-reliant with energy, but by displacing communities that are actually already self-reliant, then obviously there are problems here. And so that leads me to this final thing of where is the role in all of this of communities who are supposed to be empowered by the 73rd and 74th constitutional amendments, which I think Bhargavi mentioned, rural and urban, whereas we see, firstly, of course, implementation is poor, but secondly, even by concept, there are flaws because financial and legal devolution has never taken place. Communities don't have the sorts of financial powers or legal powers that they should have. So when we're talking about making laws, at what stage do actually communities come into the making of laws? It's still very much at state and central government levels, and the same thing with handling most of the finances. And then we say that implementation is poor. That to me is also a sign of poorly defined laws, because if the laws don't actually have a central role to communities on the ground who are impacted in the implementation, in the framing and then in the implementation, then they actually will never get implemented because the people most badly affected are not part of implementation. So anyway, so I think these are some crucial issues. So anything, again, any of you would like to say on this?
Yeah, I would just like to
Yeah.
add that so all these RE projects, for instance, are land intensive. So if we look at our land acquisition processes itself, the Land Acquisition Act was amended because of the efforts of civil society over the last 30-40 years. The 1894 Act got amended under the 2013 version, and then with more amendments in 2015. But that law has been put in cold storage. We have found newer ways to dodge that law because it has some very good fair compensation and rehabilitation packages. If you look at the Pavagada Solar Park, it is a lease method where the local people are getting a very, very petty sum of just 21,000 rupees per acre per annum. And a large chunk of the land has come from small and marginal farmers. So it has left them all devastated. If you look at the Chamrajnagar area where there are hundreds of smaller solar parks, it is a direct purchase by the developers where they have sent out brokers to lure men who are drinking themselves to death in alcohol shops, and the women of the households don't even know that the land has been sold. And if you look at the case in Mikir Bamuni, it was grant land given by the government at some point of time to the poorest of the poor, and that was snatched away through violence. So this has become a way to grab land. So under the Land Acquisition Act itself, you have a public consultation process. So that is completely, kept out. So the local people have absolutely no voice. And then this has left, and also the renewable energy policies have left states to reform and bring in amendments to their own land-related laws in every state. So it is literally laying a red carpet to capitalists to set up their shops, leaving local communities and their traditional knowledge completely buried in the dust. Thank you.
Thank you. Tara, go ahead.
Yeah. No, I second what Bhargavi is saying, and this has been our experiences in most of these cases. The first is, of course, that there has been a shift away from the Land Acquisition Act, And there have been two levels of changes that we've seen. One is the state amendments that have come in states like, Rajasthan, Gujarat. Several states have come up with amendments where they have, taken away the requirement of the social impact assessment. Many of the protections under the land acquisition laws itself have been removed for several industries, including infrastructure industries as well. So that's one level. The second is to not go for Land Acquisition Act at all, and to go for direct sale agreements. And there is this entire force fraud, luring, there has been a lot of, these, not just these brokers, but even also with the men in the families that, Bhargavi spoke about, who enter into agreements and give off their lands. And later on, the entire family is left in a very impoverished state. So it's a really tragic story, as we see, of how the land grab is taking place. But the question that you asked, specifically about the role that the communities are playing in the decision-making process. Now that role has substantially reduced because of the kind of amendments that are brought into law, which I've already spoken about: the bypassing of the public consultation procedure, Gram Sabha consents, and also in the lawmaking process itself, when the notifications, most of the environmental laws are by way of a notification. So it's extremely easy to amend it. So one of our very critical, suggestions not just a suggestion, but a demand of advocates, environmental activists has been that we need a law in place, and just, environmental law by way of notifications, like we have the EIA notification, CRZ notification, and so on and so forth, is, really pliant. It is very easy to amend these laws. It is very easy to dilute these laws. There is no parliamentary process that is followed in doing that. But most importantly, even where these amendment notifications are passed, the public comments and suggestions process is bypassed with in public interest. All these laws are shown as urgent, and then they are passed. So public consultation at the lawmaking process is completely absent in today's day. And there again, where there are specific projects, again the public consultation is not available. At the second level, there is no mechanism by which local communities can actually access the Ministry of Environment and Forest or the state authorities. There is no way in which they can complain to them or that their grievances can be taken. There's no procedure that the laws provide for, which enables the community in terms of a grievance redressal mechanism or in terms of a complaints mechanism. So again, there is a huge lacuna. So the communities are left with no option but to opt for litigation. Now, again, coming to litigation, and that's, I think, again, a very important thing that we need to discuss, and how the litigations are actually going for the community. We have, when the high courts have not been, entertaining all kinds of litigations. They are very restricted in the kind of litigations that they entertain, also because of the existence of the National Green Tribunals under the NGT Act of 2010. But the NGT itself was rendered completely ineffectual for a period of three and a half years until, from 2017 until, I think the middle of 2020. And members were not, really appointed. There were no appointments that were taking place. There were, huge number of vacancies in the zonal benches. This was also taken before the Supreme Court. And after that, the revival of the NGT and the NGT zonal benches has been very poor. So we are not seeing that kind of, lawmaking coming through the judgments. We are not seeing that kind of intervention for the communities taking place at the NGT level. So this is a really sad situation as far as the communities is concerned. And one of our central demands has to be to bring back the public consultation process, to bring back the, FPIC, bring back the rights of the communities in the decision-making process. And that has to be central to whatever demand we make on climate policy as well.
Thanks, Lara. Tulika, Shibani, any quick words on this?
I have some words, but not on communities' involvement. So Tulika, if you wanted to come in on that, I'm happy to hold my thoughts. Okay. So Ashish, with your permission, can I talk a little bit about the judgment and some thoughts I had on the judgment, if that's okay.
Yeah, go
If
ahead.
it's
And then we will, I actually have one last question for you, but that we'll do at the end.
but then
After you
I
finish,
can
you want to come
okay.
in at that stage, you can come in. You'll all have a chance for some final closing remarks if you want to do it then. It's up to you.
Okay, yeah. No, I just wanted to say a few things about the judgment itself, since we were this whole session. I mean, it's been. I'm so glad the discussion has gone in so many has touched on so many aspects. But just a few things. One thing we have to remember: some of our landmark decisions in environmental law, the outcome has always been against the environment. Many of us cite the Lafarge judgment, we cite Intellectual Forum, you look at the final outcome, it was not in favor of the environment. So, we have this bizarre faith in our, not bizarre, but I mean, for some reason, we have this faith in our judiciary, resolving all our angst in some ways. The truth is, and Tulika, I'm glad you picked up this point that, is the right part of obiter. Like, it has no bearing on the final, precedential value of the judge. It doesn't matter. As litigators, it doesn't, if the judge uttered the word, we will use it. It doesn't matter if theoretically it is of advisory, persuasive, whether a minority judge gave it's you may be right, the final outcome was not affected by the right, but the truth is that there is huge potential of this right being misused. We don't have guidance, as I said, and many of us are not sure about the value of this judgment going forward, or are entirely sure of the misuse of this judgment. But there is perhaps some scope of positive use of this right. Perhaps, I don't know. It's in our law books now forever. So going forward, maybe someone can make a good claim on their right not to be, the right against being sunk, as in that rising sea levels. Perhaps coastal communities at some point can use this right to say that the local body should be able to adapt the coast to ensure that our rights are protected, our livelihoods are not affected. So in that sense, one could see this right being used. I mean, all of us are totally cognizant of the ways it may not be used, but I think there is something to be said that maybe in future we have some hope. But I'll stop.
Thanks,
there.
Shibani. That was actually going to be my last question for all of you.
Sorry.
How do we use the judgment? That's okay. We'll come back to that because it'll be good to end on that kind of a positive note.
No, I actually
but
also
I'll come
wanted
back.
to comment on this.
Can I come back to that at the end, after having dealt with the questions that the audience has been raising, or do you want to absolutely come in now?
No, not really.
Yeah, so we'll have a final round, a few minutes for each of you to actually look at this question also, and any other final thoughts that you have. So let me, I think, folks from IMPRI, if you could also help me. One is in the Q&A. Suhastai has been very good at putting her questions in the Q&A and not in the chat. Thanks, Suhastai. I don't know if it's possible for any of the people in the audience to speak. Otherwise, I will open up the questions.
I think they can speak. We can give them the access to the mic.
Okay, so Suhastai, you have several questions. Would you like to place one or two of them? Maybe not all of them. We may not have the time. Go ahead.
Yeah. Actually, I would say that maybe the questions you people can go through even later, but I would like to use the time for suggesting a couple of things. Maybe I have put them in the form of questions as well. Meaning, first, thanks for the excellent discussion. And Bhargavi and Lara, we all lived all the problems together. So I share all the things. And nice to see Shibani and Tulika, young people, raising more questions. I have a suggestion, like it was done in case of gender sensitization. How about considering some kind of a orientation program for the judiciary? And one major thing that is needed in that is the science behind the climate crisis, which we have Samyada who talks very nicely and simply. But if the science behind and the severity is conveyed properly to the judiciary, at least as human beings, they may get sensitized and we can hope for something better. That is my one very basic thing that I wanted to share. The second is, as the grassroots struggles, we have always been asking for a right of the affected community to say no to the project, which is never recognized. And we all know about the ways the laws are bypassed and all. But should we assert this? Meaning, we have two different kind of communities. One is the more urban, better placed ones, whom we need to orient again to say that you cannot go on having more and more energy. So you have to check, which definitely Ashish would agree. You have to reduce and minimize your energy demands. No alternative energy also can fulfill all if you go on increasing. And you have to accept and respect the rights of all the remotely based tribal, non-tribal communities, of first rights of those communities to the natural resources. Because it is by disrespecting and violating their right to natural resources, we all have been grabbing in the name of development all their natural resources. So can we somehow think of connecting these concepts to developing programs and hope for the best, at least by such sensitization program? Thank you.
Thank you, Swasthai. I think on the first question, there's also something in the chat. I'll just read it out by Dharmesh Patel. He says, clearly current legal magistrates are not trained in giving climate and environment related judgments. What could be done to form countrywide comprehensive legal guidelines for all future climate litigations to follow? Maybe this is connected to Swasthai's first question. Let's deal with that first, and then we'll come to the second one. Who'd like to respond?
Yeah, I think we should start with, inculcating the habit of bird watching among all judges and then maybe even in law schools, it should be made mandatory that everybody becomes a bird watcher, and nature walks should become mandatory courses, and some kind of connection to nature. That could be a good start.
I'd be happy to take those bird watching sessions. Okay, who else wants to respond to that one on training, orientation, etc.? Tulika, yeah.
Not on training and orientation, because I don't believe that judges should be the ones deciding on policy on the basis of their interpretation of science or somebody who's interpreting it for them. I don't think that's their mandate or their remit. But in terms of reducing energy demand in urban centers, so there was this whole life idea that came out last year, which talked about lifestyles for environment, which was pushed a lot by the government. And the idea was to talk about ways in which people can reduce their overall resource and energy consumption. I think a lot of these ideas are there, and they're very piecemeal. Like they talk, about very limited types of reducing energy demand reduction. Maybe my approach is a bit technocentric for this discussion, but there are a lot of innovations that are actually coming out now. I actually look a lot at energy technology and the kind of different innovations that India could perhaps prioritize in the future. And there are many technological innovations that are coming in that can help reduce overall energy demand from city centers, whether it's in terms of changing the way that we heat or cool buildings, whether it's in terms of making our existing energy more efficient, whether it's in terms of changing the way in which we produce solar and wind power, so that perhaps the emphasis need not be so much on large-scale power plants in the future, but on more decentralized power. For that, we need different kinds of legislative change. We need things like that. We need power market legislation that permits decentralized power production in a different way. I mean, there are all these exciting innovations that are out there, but it's difficult to get them into the country because we don't have access to the technology, we don't have access to the resources. And at the same time, we are in this chase against China where we're trying to catch up with them. So there are solutions that are technological and non-technological, but it's a matter of articulating how to balance out the two and what that might look like for an urban center.
Thanks. Shibani, are you ready? Yeah, go ahead.
Yeah. I think it's a great point about having our judiciary being more kind of aware of what's out there, the science, the options, kind of what's in the balance. But I think we also have to be aware of the fact that it's an adversarial system. So it's not just the judges, it has to be the whole legal fraternity, which has to be, and therefore Bhargavi's point that from law school only start bird watching, I think is, we have to catch them all young. But I think that's a point well taken. But in that sense, I think judgments like this have that softer value of bringing these issues in the conversation. It may not be in the way that all of us who are fighting the larger fight of renewable energy, land acquisition, there I see the limitations of the judgment. But honestly, you see the fact that once Justice Chandrachud has started talking about this, we will see all other judges, somehow there's a completely unconnected case with Andhra Pradesh Forest Act, which has Supreme Court judges talking about and citing this judgment. It is not connected, but they are citing it. So I'm saying these kind of things will seep in, perhaps in the beginning in unconnected, irrelevant, unreasonable ways. But I think, down at some point, public trust doctrine and all now is kind of getting fleshed out. So I think apart from these awareness sensitization programs, the National Judicial Academy, state judicial academies can take the lead, and legal fraternity also has to take some responsibility. I think this judgment and many others like this could play a role, I would say, and leave the definition of role kind of open. Yeah.
If I may add a couple of more points. Ashish?
Yeah, go ahead. Quickly, because we're actually
I think just to add to this, a little bit more of experiential exposures, because there is always this gap. To those of us who do science, we don't understand law, and those of us who do law don't necessarily understand science. And given the kind of cases ESD has been fighting in court, be it the waste issue or the lake issue, explaining science and navigating those areas have been extremely difficult. And some of the cases of ESD has gone on for like a decade now. But in the waste management issue, we managed to get the judges to come and see the landfill themselves. That was a pivotal point. And in case of the biopiracy case, I was amazed at the fact that at that time the CJI in Karnataka was Vikramjit Sen, and the first thing he said looking at the petition was that you people should be protesting outside the US embassy because they have not signed the CBD. So even before coming to court, go and protest there. So that is the kind of, training and exposure and experiential exposures that they need. I just wanted to add that. Thank you.
Thanks. Talking about exposure, I remember 1984, the Shriram gas leak in Delhi, and the toxic cloud actually went over the Supreme Court. And the very next day, the case that MC Mehta had filed 6 months before actually got taken up. So various different kinds of exposure might help. Okay, Lara, yes, go ahead. And then I'm going to come to, I think there's one or two other questions in the chat which I can deal with. Go ahead, Lara.
No, I also think there's a huge need for education among the judges, because they are not really abreast with, climate related issues. They're not also aware of, the situation on ground. They don't understand how these laws are playing out on ground. They don't know the local laws, very well. So there is a huge gap in terms of the kind of knowledge that they have, and there's very limited amount of time that they give to litigators also to fill this gap. So education through the court process itself is not really happening. So there is a need for more of these these sensitization or refresher programs with judges, and I don't think they're happening really, or they're not happening through environmental experts who are working on the ground, who are working with communities, and who are invested in these issues at a local level. So there is a need to bring that into conversation in the courts and to somehow bridge that gap. The other thing also that another point that was made was on the judgment itself and the manner in which we can use it. I already, shared my skepticism about the judgment and how it can be a tool for greenwashing and how it might pave the way for more of, more of environmental destruction, habitat destruction in the name of, green energy. And our whole concern is we all know that we need just transition. We need transition to renewable energies, but it has to happen in a just, fair, and equitable way. It has to happen by protecting the environment and protecting the rights of indigenous communities. That has to be at the crux of this transition. And that's not the manner in which transition is playing out. And that is not the manner in which investment for this transition is coming in. There's the focus is not right now on phasing out, the focus is on land grab. So how this judgment will actually play out, I'm not so sure about. But of course, like Shibani said, we will be using it in courts. We will be using it to assert this right in different contexts, and especially in the context of climate impact, because that's where, this judgment comes in. So where there is, where there is climate impact, where we are invoking disaster management laws, we are going to be using this judgment, is how I foresee it happening. But the concern is, will it backfire? I think it's going to be used far more by project proponents. I think it's going to be used far more by the state. I think it's going to be used far more by the energy sector. So that is where I think the concern lies.
Thanks, Lara. And I think that's where the issue that Suhasita and some of you have also raised about free, prior, and informed consent of the communities on the ground, which we don't yet actually have, except to some extent under the Forest Rights Act, where in fact that's one of the where people have gained collective forest rights. They are at least able to resist both people power, but also legal power over the forest, governance over the forest. So we need much more of that. And I would say actually, in some way, free, prior, informed consent also of nature, who's asking the species on the ground, right? And I think in that sense, the rights of nature discourse, even though it's somewhat limited in terms of legal thing, is interesting and important, including, say, the High Court judgment in the Uttarakhand High Court judgment on Ganga and Yamuna, which also could much more significantly be misused than properly used. But maybe those are things where we can kind of dig deeper and see how we can actually truly be giving powers to those on the ground, human and non-human, that are badly affected. There's one, and I'm going to come back to this last round from all of you, but there's one question by an anonymous attendee, if any of you wants to address that. Given that the focus is largely on economic growth and development, what is the kind of mindset shift that we would be requiring to achieve this philosophical consensus, which I think Tulika had mentioned. But beyond that, at the risk of using this word, what would be the incentive for government entities and other stakeholders to shift their focus to climate and environment? Very big question. I think perhaps we need another 2-hour session on this, but any quick responses from any of you? And then Dharmesh has said, what be the role of data on climate change in our country in building good cases in climate litigation? So perhaps one or two of you can just quickly respond to these. Yes, Lara, go ahead.
This is the first one. I think the incentive will have to be political one. It will only come through public pressure on the ground. So I think I'm very clear about that, because otherwise the only incentive they have is coming from the capitalists. It's a developmental economic incentive. So, and that's that's how the political will is shaped right now. So if we want to change that, it will have to be a political threat that we give, and it will have to come through public pressure.
Right. So the mass people's resistance movements are absolutely crucial here. Anybody else wants to comment on either of those questions?
So about the data point,
yeah.
Sorry, Tulika, did you? Yeah. So I mean, I'm not no expert, and I don't specifically talk about data, but I just wanted to say that some of us were thinking of that climate law. It's not so much about creating offenses or penalties and all, but to create systems where climate data, climate scientists can modeling, kind of thinking of timelines and timetables. So all of that can then be facilitated, can be institutionalized. They can have a backing of, I mean, I know this all sounds lot in the air, but I think we need to do something. In the absence of it, we are not necessarily better off than we are, So I feel that we need to create spaces and forum where data, modeling, on ground inputs from communities. I think that is definitely data that needs to be also brought in, but I think it will be brought in a more systematic or systematized fashion if there is a process laid down. And I'm putting all the caveats of lack of trust in many of the processes that are already there, but it is what it is, and we'll have to place our trust somewhere.
Also, of course, data and information from the ground. No, a lot of communities are actually talking about what sorts of impacts they're
I meant
seeing.
that.
So,
I meant that should be considered as crucial data in the climate debate.
Right,
most
that's what you
certainly.
said.
Yes.
Yeah, absolutely. Okay, great. Ramit, the question that you have, I think, is kind of partly been answered. So what you're saying is, how will this judgment impact the implementation of acts like PISA, Biodiversity Act, FRA, etc., where the act might be in conflict with the judgment or vice versa, rather than what will prevail? And I think Bhargavi and Lara have both been talking about how this might promote and spur large-scale so-called renewable, I keep saying so-called renewable energy development, and will give project proponents and governments another reason to say that, okay, we can do away with people's rights, etc., because the national interest is there, climate has to be dealt with, etc. So I think in some senses this has been answered, but I'm going to go to the last round for all four of you before I do some very short closing remarks. And my question was going to be, which Shibani and Lara have already partly dealt with, is that how do we use the rights part, the right not to be adversely impacted by climate crisis? How do we further use that in any of the work that we're doing? So brief answers from all four of you. Let me go the reverse direction now. Tulika, you want to start?
I think I'd like to go last on this one. I'd really like to hear what everyone else has to say.
All right. Shibani?
Yeah, so I mean, of course, I've already said that I think communities can use this right to demand action from the state. Incidentally, the judgment also identifies the state as the primary entity responsible to ensure that this right is not violated. So I think one vulnerable communities such as those living on the coast can say rising sea levels and you should take action. But I'm also thinking this can definitely come in the regulatory challenges, all the challenges on environmental clearances, forest clearances, wildlife, diversion or denotification of wildlife sanctuaries and so all of these legal challenges that are already there. I think an added layer of a legal argumentation in the form of rights and a challenge on rights, I think can certainly be brought in and can be used. I have already said that I am, and I agree with others on this panel, that it is also likely to be used from the other side, saying that they are also ensuring that people's rights against adverse impacts of climate change are not affected, and could, in that kind of creative, novel way, be also used. But also, just as a final point, and just that I think this the fact that this judgment came out and reinvigorated our discussion, or rather started this discussion on the need of a right, the need of climate litigation, bringing climate front and center of legal arguments. I think there's a real kind of contribution of this judgment going forward.
Thanks, Lara. Thanks, Shibani. Sorry, Lara.
Yeah, I think it's going to, I've already told you, my reservations about, how this judgment will be used. But about more than about how it will be used, I think it is about who it will be used by. So I think that those reservations have already culled out. But one way in which I think, we as environmental litigators, will be able to use it is to strengthen our environment on the precautionary, our arguments on the precautionary principle, on, bringing in preventive measures, and obviously also the challenges to the, environmental clearances, to the policy deregulation, the dilution that is taking place. So I think these are some areas in which, we will be able to, use the judgment to argue that there is a fundamental right to be free from adverse climate impacts. And because of the recognition of this right, there is a need to, to enforce the precautionary principle and prevent environmental damage coming from projects or coming from these policy dilution. So I think this is one place where we will be able to use it quite. I don't know if it will be an effective use, but it will definitely be a use in our regular litigation. But I think where energy is concerned and where renewable, where we're talking about green development, where we are talking about renewable energy, where we are talking about projects itself that are positioning themselves as green alternatives. I think that is where this judgment may actually fall flat on our face. So this is a double-edged sword I feel that we have for us right now. Yeah.
Thanks, Lara. Bhargavi?
Yeah, so I think, see, first of all, communities are being displaced because of climate change. It reminds me of a little anecdote from Kerala where we were talking to law college students in a workshop on climate change, and one student shared her personal story where she couldn't get loan for her education based on the house that they were living in, because the bank said that your house will be submerged due to climate change, so we cannot take that as collateral. So as it is, we have communities facing these kind of challenges, and on top of it, if this particular judgment is going to be quoted and used and misused, and also the kind of policies that are coming out as it is based on the renewable energy policies, I think people will be displaced from their lands and livelihoods. That will again push them towards the impacts of climate change. So they will be, like Lara said, a double-edged sword. They will, face the brunt of it in either way. So in that case, I think there should be some kind of protection built in the policies, where they say that, where we are able to say that the commons are not taken away, or those living on the commons will get some kind of a package where their livelihoods will first be secured. Today, it is people's livelihoods that are at stake. So there has to be this critical habitat, like, it reminds me of the Subramaniam Committee report way back in 2014 or 15 that came. It said go and no-go areas. So like that, I think we should have go and no-go areas for RE projects. And then it's important to go back to what the IPCC itself is saying, because IPCC very clearly says that land tenure security is very important to address climate change. And here we are pulling the land out of the community's feet. So it's really important to go back to that, I think. Thank you.
Thanks, Bhargavi. Tulika, over to you.
I think taking from what everyone has said a little bit, there would be three things that I would like to use it for, but I'm not a climate litigator, so I work in policy. One, from a financial perspective, one of the major risks to communities and populations, like vulnerable populations, is the lack of insurance in the event of a adverse climate event, such as a flood. That is absolutely not there. If you have a right against the adverse impacts of climate change, you should be able to access insurance products that protect you from it. It's been very difficult to persuade financial institutions to get them to create these products. This would be a great way to actually push for it. Second, as a policy researcher, I would really like to use it to find out, or to at least lay out this, based on this assumption that we have this right, what are the policies working backwards from this right? How do we change our policies to implement this right? That would be another. And third, from a community perspective, what do communities think about having this right? How would they like it to be enforced? Because from what all of you are describing, communities are not being heard. So what is it that they have to say on it? And how can we use this right to articulate what they have to say, either in the Supreme Court or elevated at different levels?
Thank you. So we are actually just a minute over time. I'm going to start winding up now. I don't have any major closing remarks. The only thing I do want to say is that I think, firstly, of course, fantastic, all four of you. It's been amazing. I've certainly learned a lot. I think we've kind of dug deeper into many of these issues. And of course, all these issues are worth many, many days and hours and months of discussion, but I think we've touched on many of them, gone deeper into some of them. So thank you for that. One thing that kind of maybe I can suggest to IMPRI to anchor is that it seems to me that something really productive that could come out of this discussion, if all four of you are also interested, is a kind of a guidance note for whoever, for the litigations, for civil society, for people in administration and government, for communities, on how this judgment, I'm talking only about the rights part of the judgment, the right against adverse impacts of climate, how it could be misused and how to avoid that, but also how it could be used, including some of the points that I think all of you have made. If we can bring out I mean, obviously not like a PhD, but like a 10, 12 page document which lays some of this out, whatever we all agree on, it seems to me it might be of great use to a lot of people. To lawyers, to maybe some judges will read it, to those who are making heat action plans or whatever. I mean, different kinds of people who are active in, and many communities who are actually also, like Tulika just said, who are also wanting to take action on this sort of thing. So, and it could be translated into languages. So this is a proposal to IMPRI. If you'd like to anchor this, I could certainly be involved, and I hope I speak on behalf of all the four panelists that they could also contribute to this. So with that, many thanks. Sorry, and I just want to mention that I think one or two of you did say that the use of Article 14 in this was very, very interesting, because like I think Lara, you said Article 21 is used a lot, but 14, and therefore bringing in equality and human rights and all of that into it, and I keep saying rights of nature, would be a very useful thing to explore. All right, with that, many thanks to the four of you. I hope, and to all the participants who joined us, I hope it's been useful for all of you. Over to IMPRI for closing this.
Thank you very much for such an enriching session. So with your permission, we can go for the vote of thanks. Ashish, sir?
Oh, I had already handed over to you, so it's all.
Okay,
it's all
all
yours.
right. Okay.
Yeah. Sorry, I didn't realize you're asking me.
Thank you very much. Also, sir, just to add, we will adhere to your suggestion of creating a guidance note. We will definitely take this on. Thank you very much for the suggestion. We will reach out to you. And so as we come to the end of the session today, I, Shweta, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks. On behalf of IMPRI, Center for Environment, Climate Change and Sustainable Development, I would like to thank all of you for attending today's deliberation. A panel discussion on transforming climate litigation, the role of MK Ranjitsinh versus Union of India in shaping India's climate policy. We are grateful to our chair for the session, Mr. Ashish Kothari ji, and our esteemed panelists, Ms. Shibani Ghosh, Ms. Bhargavi Rao, Advocate Lara Jasani, and Ms. Tulika Gupta ji for taking part in the discussion and enlightening us. We will thank all of our participants who have raised pertinent questions and have actively participated in today's deliberation. We are grateful if you're watching us later on YouTube or listening or reading our podcasts and publications. You may also find more thematic events and book discussions under the IMPRI Web Policy Talk series. And we hope you continue to join in future to our IMPRI Web Policy Talk and Web Policy Learning. Wishing you a good evening. Thank you very much.
Thank you.
Thank
you
you.
all.
Thanks a lot.
Thank you.
Thank you. Night.